welcome to another episode of Talk Lex. I'm Scott Peterson. I'm here today with Barrett Mack. Barrett owns a law firm in Albany that focuses on a couple of different things, but today we're going to be talking about matrimonial law. I've known Barrett for almost 20 years. He's a good friend. He's a guy that I, for a lot of clients and prospective clients too, because I think he does a great job. He's got his head on right, and he's a smart guy. So Barrett, thanks for joining us today. Why don't you kind of tell us about, who you are and what you do, from your end?
Certainly. First of all, thank you for having me on. I appreciate the invitation and the opportunity. My name is Barrett Mack. I own the law firm Mack and Associates. We are based out of Albany, New York. We are primarily focused on matrimonial and family law. I would say 90% of the practice focuses on that aspect. We have, in addition to me, 4 full-time associate attorneys dedicated to the practice of matrimonial law, plus 2 paralegals. So it's a larger practice and one that I'm very proud of, and it certainly has been a labor of love. I've been on my own practicing since 2008. The firm Mack and Associates has existed since 2014, and I've been licensed to practice since 2005, as you know. We've been admitted, hard to believe, 18 years ago.
Yeah, it's funny, and I remember sitting with you after you split off, or after you kind of went out and started your own thing, and I was still in the trenches with a firm and asking you if it was something that I could make work. And we've taken different paths, but I think probably for somewhat similar reasons over the years. And it's funny because matrimony, probably more people call us for recommendations for divorce lawyers than anything else. I'd say maybe like traffic tickets or something like that, right? But it's so foreign to us now. I haven't thought about a matrimonial law issue since law school, and it seems like it's obviously one of the most sort of prevalent areas of law. I mean, I don't know if the statistics are still 50% of marriages end in divorce, but that seems about accurate. Is that right?
Absolutely. I mean, in all ages, all walks of life, it doesn't discriminate. It's well over 50%. And let's just say the pandemic hasn't brought people together as they're struggling in their relationships. So we've seen an uptick in filing, post lockdown, for sure. One of the things and you bring a good point. Matrimonial law is so special because it's not just good enough to understand the domestic relations law. You have to have an understanding of tax, bankruptcy, corporations if there's private businesses that need to be valued, valuation issue, custody, psychology. It is a vast field and very complex because the litigants that appear in a matrimonial action are frankly just not in their right mind. And I don't mean that in a negative sense, but going through a divorce is probably one of the most traumatic things one can experience in their lifetime, right? And see, these are very, wonderful people that are coming to you in a very, very difficult moment. Their finances are on the line, contact with their children on the line, on the table, and there's just so much uncertainty. And it's your job as a practitioner to guide them through this unpleasant process to try to get them to a spot where they can conclude their marriage and then begin to heal whatever trauma they have experienced, both in their relationship and through the actual process.
Yeah, you bring up a point I actually was going to bring up later, but I guess we'll talk about it now, which is, we people who are in, fragile states often in whether it's like a catastrophic PI, a personal injury case, somebody has died, whether it's employment discrimination, they've lost their job, they're scared out of their minds about where their next dollar is going to come from. I feel like a lot of what we do, and this kind of applies across the board, even to some of our more business clients, but I feel like a lot of what we do is we try to help guide people to save themselves from bad emotional-based decisions. How frequent do you find yourself playing that role where, you're almost playing the role of like a counselor or psychologist, where you're helping people pull back from decisions that they want to make in the emotional moment, but that, is, from experience, is going to be totally against their self-interest?
Yeah, most of the time. I counsel, most of the time I'm telling clients not to do a particular thing. And then I explain why. Because, just the raw emotion involved, there's an instinct to try to hurt the other side. And oftentimes when you do that, you're hurting yourself, you may be hurting your children, which is really something that is you want to avoid in this process, obviously. And it's also just the amount of money that acrimony results in amounts of money spent. I mean, an average, just to give you an idea, a custody trial these days, just a custody trial could be north of $50,000 for each side, easily. And, you know, you really want to, from the onset, try to position yourself, if you can, sometimes you can't, position yourself to a position where you can ascertain, try to calm the fire down, right, and ascertain what the issues are. Because, you know, the actual body of law is not terribly complicated. You know, a lot of times what you're doing, example, would be equitable distribution, right? That's one of the many topics. You gather all of the, you know, assets and liabilities that one accrued during the length of the marriage. Then you classify them either as marital or separate. Then you value them, and then you distribute them. Not terribly complicated, but when the emotions are there, people will spend sometimes thousands of dollars fighting over a blender or a radio or some item of personal property that had some type of significance. And you can't just, when you're counseling your clients, you can't just say, you know, get over the crock pot. But you can try to explain, you know, it's cheaper if I go out and buy you one, as opposed to having two attorneys argue over these items of personal property. You know, and that's just one of many examples where emotions can get the better of the litigants. And I think it's very important from the onset to when somebody is selecting their attorney as their matrimonial attorney, you want the attorney that's going to tell you to be reasonable. You know, you don't want the attorney, and there are some out there for sure, that just stoke the flame, right? Because the longer a case lasts, the more time that's invested in the case, in theory, the more money the lawyer makes. And you want to, you know, really, you know, kind of avoid that.
Yeah, I mean, that's so important. And because you hear people, look, I mean, there's people come to us in employment or PI cases and they're like, I want a shark. I want somebody who's going to kill for me. And it's like, well, all right, well, we can do that, but let's stop and think about what we really want to achieve here before we go, you know, head first into the abyss that we can't pull ourselves out of. Because as you know, it's once you come out guns blazing, it's very hard to backtrack. And I imagine it's even more difficult in your situation.
Absolutely. And, you know, I always tell clients, they'll say, Barrett, or, you know, Mr. Mack, I hear you're a bulldog. And I said, yes, I'm a bulldog, but you don't want a bulldog. Okay, you don't. That's the easy part. It's easy to play the slash and burn game. Who can, as a lawyer, go in and blow everything up, litigate everything, make everything an issue? That's an easy thing to do. What's more difficult is what I just described. Sitting down with a fine-tooth comb, going through the issues, and suggesting reasonable proposals so that people can move on with their life. That is most definitely more difficult.
Do you think your perspective on that has changed? Because I think personally about my sort of how I kind of conducted myself as a young lawyer versus now. And I think about, I started out working in like a defense firm, and I was always really aggressive with my motion practice and, you know, trying to get cases dismissed. And I think as I've gotten older and I've seen more of both sides of it, and I've gotten a better perspective, I think my approach has become much more along the lines of what you're talking about, where you're looking at things more holistically and trying to figure out what the best outcome is versus just putting your head down and barreling through. And maybe that comes with age. Maybe it's just personality. I'm curious.
Yeah, I think it's age, but it's also, I think this is a good time to bring up how much matrimonial law has changed as I started practicing. You know, in 2010, New York finally caught up with the rest of the country and issued its no-fault divorce. Right back before 2010, you had to prove a ground in order to get a divorce, like adultery or cruel and inhuman treatment, and that's very difficult to do. Also, there were judges in the area that were very proud of saying, I've never once granted a divorce after a trial. So imagine spending $50,000, having a trial on grounds, losing grounds, and not being divorced. That happened.
Oh, wow.
And it also, when you were negotiating settlements, you could use that as a chip. Look, I'm going to make you prove your case. Go ahead and try to prove cruel and inhuman treatment. Otherwise, give me X, Y, and Z, and then we'll consent to it, right? So that all changed in 2010. Fortunately now, no fault. All you have to do is say under oath that your marriage irretrievably broke down for a period of at least 6 months. Courts don't know, they don't want to know why, they don't care, okay? You just have to say it, you don't have to prove it. And then if you say it, then you move on to the ancillary issues in the case. So what needs to be resolved? Equitable distribution, which is property, asset, and liability distribution. Child custody if there are, minor children under the age of 18. Child support if there are children under the age of 21. Maintenance if there's a vast disparity of income or a disparity in income, depending, and counseling. Those are generally the issues that need to be resolved in order for the divorce to go through. And they get resolved either by an agreement, and that agreement can be in writing or can be put on the record in open court. You'd have to sign something called a Lashinsky affidavit, but in any event, those are the two ways to do it by agreement. And then, of course, if you can't agree, you do eventually have a trial and the judge will make the decision. 98.8% of cases settle because it is so expensive. The system is really designed now to promote settlement. As an example, what's available to litigants is free mediation. You can ask a judge to, if everyone consents, you can ask a judge to refer to ADR, and then a court attorney will be assigned as a mediator to try to resolve the issues. And it's generally, retired attorneys that were in the field, so they know exactly what's going on. And that has been, I think, producing some successful results. And it's nice for the clients because it's free. So that's an example of how things have changed. Also, every time you're having a conference with the matrimonial judges and the family court judges, they really are pushing settlement. Oftentimes, as you get closer to a trial date, your trial judge may bring you in 3, 4, 5 times before trial to really focus on getting the settlement, because that, frankly, is usually in everyone's best interest. Now, there are some cases where the issues in the case a judge will have to make the decision, and they're the ones that go to trial. And then, most of the time, if there's a trial, there's an appeal that follows, right? So we do a lot of appellate work here. In addition to our trial work, I think about 40% of my practice these days is appellate work. A lot of reported decisions that we are proud of in the appellate division. But basically, if you have the trial, you can almost guarantee there's going to be an appeal, and that can be an extra 15 to 20,000, depending on the size of the record and all of those things.
What do the appeals typically arise out? If there's any typical, is it the equitable distribution piece, the custody piece, the support? Is there anything that's more likely to be a challenge than, or is it any of them?
Well, really any of them. I mean, generally with the appeals, it's a custody issue, and it's very hard to have a custody determination by the trial court overturned. I mean, you have to show abuse of discretion. The courts have a wide variety of discretion. But a lot of times, courts will do funny things. One appeal we won recently, we filed a petition for a relocation, and the child was 15 years old. There was a previous relocation application made when the child was 9, okay? And so the family court, and I'm not necessarily disputing the logic, but the family court dismissed the petition after a motion to dismiss was filed, saying essentially res judicata. Right? We appealed that and said, no, we should have had a hearing. The circumstances are different, and we were successful in that appeal. Like, that's an example of sometimes courts will do funny things and not follow some some concepts like you should have a hearing before a petition is dismissed generally. Another example might be one we had recently, evaluation issue. We were not trial counsel. We handled the appeal. Our client was only awarded 5% of the business. After the appeal, we got a 15%. And that 10% was actually a big number as far as so the juice was worth the squeeze in that one. Some cases, there's a case that we handled in 2017 where the trial judge, based on an expert forensic evaluation, ordered that a child, I think the child was maybe 7 or 8 at the time, completely moved to North Carolina and had no contact with the child's mother for a period of 6 months, based on this concept of parental alienation. and all of this psychology. We fortunately, not only did we get that one overturned and reversed, but we got to stay on that right away. So the child never actually had to go to North Carolina to live with his father, who he really never had any kind of, he had contact with, but not that type of relationship, where he was actually residing at the house for, a significant period of time. So, there is a lot of, there's anything can happen, so the reason why all the issues are tried is at the appellate division can reverse, they can affirm, or they can review the record and make its own decision. And they do that a lot. So the thinking is at that point, if you're going to appeal, you want to raise every single issue.
Yeah, I mean, it seems like it kind of goes back to your original comments, which is, I would imagine when it comes to thinking about an appeal and what issues to appeal and whether to bring an appeal, you have to look at whether you're being emotional or whether it's an issue that really justifies it. Because then it goes to the second thing you mentioned, which is the expense. And I'm just sitting here thinking about, if it costs you $50,000 for a custody hearing, you're talking about a trial and then an appeal. I mean, I don't know, there are lots of people who don't have $100,000, $150,000, $200,000 lying around to pursue these issues, right?
Right.
I imagine that's got to be a sticky point in a lot of cases.
Absolutely. You're constantly, in my line of work, doing a cost benefit analysis. And then that's your job as a practitioner, is to, explain why it is, you shouldn't do X, Y, and Z. And then you try to tie the costs associated with it. But there are some times when no matter what you say, that they, you hear it all the time. They want their day in court. So fine, if you want a ticket to the show, no problem. You'll get the best show. But, sign this letter that says, I'm advising you not to do this. And then we'll go ahead and, do it. A lot of people, they think, and then we're kind of jumping around, but they think, I'll give you a custody hearing as an example. They think, okay, well, we're going to get to trial, we're going to say our piece, and we're going to get a decision. That doesn't work. In the family courts are so backed up. You get a trial, as an example, you get a trial date in January, then your next trial date may be in March, then it may be in August, right? So it takes 6 months to a year, sometimes just to complete the trial. And then when the trial's done, you have to order the transcripts. That's another 45 days. Then you have to submit findings of fact and conclusions of law. That's another 45 days. And then the judges have their 60 days generally to make the decisions, and they're very good. They are on top of it. Really, we are very fortunate. We have wonderful judges, both in the family court and the Supreme Court, that deal with these issues and roll up their sleeves and actually, try to help. But when you get to that moment where you can't get an agreement, people have to realize that the concept of a trial, it's not like they see on TV where you get a result right away.
Well, it's not even like our practice, right? I mean, if I have a personal injury case or a malpractice case or even a discrimination case that goes to trial, it's a jury trial, right? We set aside a week, maybe 2 weeks. We pick the jury, we present our proof, the jury makes a decision, and that's the end of it. I actually don't even think I realized until relatively recently, when I was having a conversation with someone, that the trials in your line of work are so spread out the way that they are. So they're just because most of the people who listen to this aren't lawyers. So when you say a trial, it's not like a jury trial on TV. It's a trial with a judge, and the judge hears different parts of the trial at different points, and it could be months apart, is what you're saying.
Right, and it depends on the calendar. I mean, a lot of times, our family court judges, certainly their calendars are completely, and they have no fault of their own. They're completely booked. And so, and I've been in times where I'm having a custody trial and there's an emergency neglect proceeding that comes in, and you get bumped to the back of the line. I mean, there's rules of engagement. There are certain cases that take, that have a preference over other types of cases. So, it is just important for the clients to know that I want a trial, I'm never going to settle. And it's like, okay, but, let's talk about that. And here's what I think I can do. And I have a very simple philosophy. If I can secure a result in negotiations that I think is either on par with what I would get at trial or close enough, I view it as my obligation to do whatever I can to convince the client, absent duress, of course, but to convince the client why they should accept the settlement. If, on the other hand, I know or I think I can do better at trial, I let the client know, and then they make a decision if they want to invest, that kind of money in a result that's not guaranteed, but based on 18 years, I can say, certain things are likely to happen. So yeah, it's just Go ahead.
I was going to echo that. I mean, that's exactly how I approach our practice as well. I have this conversation at least probably once a week with clients where I say essentially the same thing, which is, if we can achieve through settlement or resolution something equal to or obviously better than what we could get at trial and remove the risk, because for us it's a huge risk in most cases, because on the plaintiff side, if you lose a trial, you get nothing, obviously.
Right.
Then it's something that you have to consider, and that's having that conversation about emotions with clients again, and trying to play the, let's look at this very rationally card. Which brings me to, I kind of wanted to circle back to talk about mediation a little bit.
Sure.
Because so we have in our practice, and I know you do some civil stuff outside of matrimonial, but I'm not quite sure how much anymore. But we mediate cases a lot. Mediation's become a lot more popular in the general civil practice, and in the employment practice it has been all along. But over the last 10 years, it's become something that it's considered in most cases, if not certainly not everyone, but most cases the idea of mediation comes up. I was interested to hear your perspective on how mediation in the divorce world has changed over the last few years, and how it's changed the approach. Because now it seems like every time I see a press release or an article, it's all about somebody's changing their practice to just doing divorce mediations. You talked a little bit about it, but how has it changed? How's it changing your perspective? What do you think about it generally?
Sure. It's changed. Well, just recently, the courts offer it from the onset. They say if the parties want, they can go to ADR. We can sign a court attorney. It's going to be free. We encourage them to take advantage. Right. So that's one big change. But mediation is appropriate for a lot of cases. There's a few that are not. If there's issues of domestic violence, of course, mediation is not appropriate. If there's substance abuse issues, that generally doesn't work. Or sometimes there's so much toxic poison between the two litigants that mediation is just not suitable. But for a good majority of people, it can be. And I often will, when I do initial consults, I'll talk about the pros and cons of mediation. Certainly, in theory, it's cheaper. But I caution clients, a mediator's job is to get an agreement. A mediator's job is not to counsel. So it's very important, and good mediators, in my opinion, say from the beginning, go get lawyers, okay? And then you have consultations with your matrimonial attorney before you have the mediation session. Because you wanna eventually get to the point where there's an agreement in place. And the big pitfall in mediation is for parties that don't consult with lawyers, a lot of times they spend a lot of money, and then they go have a lawyer review the mediated agreement, and the lawyer says, you're out of your, you should never do this, and here's why. And then you're back to the beginning. So I like the mediation can be a good process for the right people. If I like the mediators that, one, will suggest that they retain attorneys from the beginning, so there's no surprises at the end. Two, I prefer the mediators that prepare at the end a memorandum of understanding, or what I like to refer to as a term sheet. And then that agreement gets over to one of the two lawyers to draft the comprehensive matrimonial agreement. Because this is key in my mind. Mediators that attempt to do the agreement, even mediators that are licensed attorneys, don't do it right a lot of time. As an example, in order to, if you agree on a child support number, and that child support number deviates from what the statute says it should be, there's about 3 pages of language that you better have in your agreement in order to make sure that that's enforceable. Just this past year, I've had 2 cases. One where I came in as counsel, there was a mediated agreement in place. It was in front of the Supreme Court, and I made a motion to set aside the child support, and it had teeth because they didn't do it right. They didn't recite what's called the statutory catechism, which, that's a whole nother topic. But basically it's, here's how much it should be, here's why it should be that much, and here's why we're deviating in front of it. These are the factors we consider. If you don't do that, the agreement's void as a matter of law. I have another case where I was retained to represent a litigant. They had a mediated agreement by a mediator. There was the mediator is not an attorney. and it was at a time where we were shut down in the pandemic. So there were specific e-notary requirements. You could take a notary electronically, but you had to follow 6 steps. They missed one. Okay, so they moved to set aside the agreement. And in matrimonial law, if the jurat's not right, you're done. The whole agreement is off. It's very draconian. That's why it's very, very important to do it right. So they made this motion to set aside. We had a hearing. I was successful. The court saw it my way and said, it's still a valid agreement, but it's up on appeal now. So who knows? It's just an example of here we are. We spent this money, all of this emotion. We think we have an agreement. We're done, and no, we're not. It's actually worse.
Yeah, it sort of defeats the purpose of trying to mediate in the first place. And I think what you said in the beginning is really critical for people to understand, because I've had a couple of friends go through mediations pre-lawyers, and I think the public doesn't necessarily understand that the mediator has no legal, ethical, or fiduciary obligation to either of the parties and can't give you legal advice. I mean, unless I'm missing something, a mediator can't be giving advice to both sides to a dispute. And so I think it creates, look, it makes sense in an ideal world. And I think, I think your points about it are accurate, but I think people have to be very aware of the fact that it's important that, you bring in a lawyer at some point to confirm that, what you think is happening is actually happening, A, and B, that it's actually in your best interest, right?
Absolutely. And C, they're the ones that are drafting. The lawyers should draft the comprehensive agreement. Not even the mediators that are lawyers. I find the clean practice is just send it over to, an attorney to actually do the agreement part.
Are you seeing a lot of mediators who aren't lawyers?
There are some. There are some more in the North Country, but of New York, but not necessarily around here. But still, it also, the other, why I think it's a cleaner practice, a lot of times the mediator that will have prepared the agreement for the both of them, there become issues of, well, were they representing both? One, it opens up the agreement to attack. So when I look at an agreement, or when I'm thinking about drafting an agreement, I'm looking at it, and this is exactly how I think. Okay, if my client were to fire me and hire so-and-so, how could this agreement be set aside, assuming they change their mind? That happens all the time. People sign an agreement and they get buyer's seller's remorse. It's just natural. And then they want to go back and they try to say that it was, it was unconscionable, or I was under duress, or whatever the allegation may be. It's very hard to set aside an agreement. But there are times where if the practitioner doesn't do it right, you can get it set aside. So that's why I think it's just a lot cleaner that way.
What percentage of your cases would you say resolve through mediation, just generally?
I'd say probably, so I get maybe about 15% of my cases where I'm retained for mediation consultation services are successful. They kind of go in with the mindset that we're going to work this out together. We don't love each other anymore in that way, but we still love each other, and we want to work collectively for our children and for our finances. If the parties come in with that mindset of we're going to have to co-parent for X amount of years, and we're going to have to get along, and we want to start from the beginning, those are the ones that I find successful. But most, a lot of them you just know from the beginning that's not going to happen.
Is this a mo money, mo problem situation? Do you see folks who have big businesses or a lot of assets more or less likely to be able to resolve things through like a mediation process early on?
Yeah, it's interesting. It's almost about 50-50, but I will say, and I'm not trying to, a lot of people that I represent that have a lot of wealth, okay, are frugal. And they know that the longer they fight, the more expensive it's going to be. So about 50% of that, of the upper tier as far as the size of the estate from a dollars and cents perspective. A lot of times the epiphany happens from the onset. But it depends on how hurt the other party is, right? So on the big money cases, if somebody's hurt and somebody, there's infidelity or whatever, that tends to stoke the fires. I have a joke I say all the time. I've literally been winding down people's affairs for since 2005, right? But it's their business affairs and the time with their children. But it generally, a lot of times, there's infidelity involved. That's probably the number one reason I see as far as people coming in to see me for divorce. Infidelity is one, money problems two, and then of course there are the cases where there's some kind of substance abuse or domestic violence involved, which is that's not appropriate for mediation ever. That you need to go get protection, and it's a completely different way to handle the case in my opinion, particularly domestic violence. That's obviously completely different. But I do want to mention something that I've noticed a lot. Substance abuse is on the rise substantially since the shutdown. A lot of my cases are very good people, good parents, but they have a significant problem with alcohol or drugs, generally alcohol. And it is a disease, and there are grave consequences for driving intoxicated with your children in the car, being the sole supposedly the caretaker and being intoxicated. I mean, you get neglect petitions filed against you, supervised visitation with your children. And unfortunately, it's sad, but the disease has bit a lot of people. And that I find is, and they're tough cases to deal with, because on either side, you don't want to judge somebody by their worst day. And, oftentimes people are. And then as the parent that is terrified that it's going to happen again, representing there's only so many mechanisms you can put in place to protect, but eventually if, the parent that has the issue with the substance, if they get help and there's some kind of maintained sobriety, that they will get contact back, they will get their time back. So on either side, it's very difficult. And it's really, it's almost maybe every third case, there's a substance abuse issue that I'm dealing with. And like I said, I find a lot of people, during the lockdown, developed the thirst, as they say. So, I try to look at it like when I'm representing somebody that has a substance abuse issue, and I try to present this to the court that, it's a disease and it needs to be treated as such. And I say to the courts, nobody should be shocked about, a relapse. Relapse is part of recovery. So yes, my client was X, Y, I had it, blue, whatever, and this happened, but we shouldn't be shocked by that, right? And I once said to a judge, if she had cancer and it went in remission and the cancer came back, everybody would be so sympathetic, but they're not when it's a substance abuse issue. You get treated like you're a piece of garbage. And to me, it's a disease, right? And you just have to try to educate the court on the complexities of the disease, which they're really starting to just scratch the surface. So, that's just another interesting part of the practice that is starting to really develop. There's things like SoberLink now, where parents will blow into a breathalyzer and the results will get sent to the attorney for the child, the court, the litigants. I mean, there's all kinds of things that go into place now.
Yeah, it's challenging. I mean, we've had a couple of cases in recent years, employment cases where someone had a substance abuse problem and they were totally stigmatized at work, pushed out the door, or whatever it was. And I think your point is accurate. It's certainly on the rise. I think the only upside there is maybe kind of to go back to what you said, is that there's becoming a larger awareness around the issues, and more acceptance that, this is something that this doesn't just affect, the lowest of the low. It's like you said, it could be, it affects all across the demographics and
equal opportunity.
Yeah. And we see a lot more of it too in our practice. And so I'm sure it's challenging and heartbreaking, especially when you're dealing with issues with children. But at least you're thinking about it, and people are thinking about it in a way that hopefully, because really, in the end, when it comes to that kind of thing with kids, you're looking to do what's best for the kids, or at least, less impactful, I would imagine. But
yeah, absolutely. And I've changed my advice. I mean, I used to, when I was younger, I said, just don't drink. right? But if it was, just don't drink, right? If it was that it was my ignorance. It's not that easy.
Yeah.
Folks that have that affliction. So yeah, go ahead.
No, I just want to touch on a couple other things.
Sure.
I won't keep you much longer here, but
No, this is great.
so you kind of talked about some of the concerns that people kind of come into you with initially. If you had to kind of use your experience, what are the legitimate concerns, and what are a couple of things that people tend to be really worried about that maybe aren't as big an issue as they think they are? I mean, we see this all the time in our practice. People get fixated on one or two issues, and it's constantly like, nope, that's not the issue. Nope, got to come back to the real problem. That's not the real problem. I know you. So,
Right.
do you see that? Is that something that comes up?
I see a lot of, yes. Money is a big one. And I see a lot of people come in and say, I'm not going to pay support. I'm not paying. I don't care what it is. I'm not going to pay child. Okay. Well, then I say, well, how much of your income do you think goes to support your children now? 90%, 100%. I'm like, great. Well, the statute says 25%. Or if you have two kids, or 17% if you have one. So think of it from that perspective, right? Things like that. But they generally they're just frightened and they have no idea. And what I try to do is I give an overview of what's going to happen. But I tell them that it's impossible for me to tell you every scenario. As the life of the case moves on, we will have to change our strategy at least 4 or 5 times. That's just the way it is. And it all depends. It depends from the beginning who the other lawyer is. I could tell people, if it's an X, Y, and Z lawyer, you've added 15 grand to your case. Or, you know what, so-and-so's on the other side, we'll get this wrapped up for you in about 3 months, no problem. But they don't know what's going to happen, and they're basically panicked. And I say we have to break it down. The only way to survive it is to break it down one step at a time. For example, I've given the retainer agreement, you'll sign that, you'll hire us. Now, the next step, we're going to fill out your financial form. Here are the forms, here are the document checklist. You need to make an appointment, with so-and-so, and they'll help you. And then we just walk them through step at a time, because it can be it's overwhelming. And if there are people, that you're representing that do have maybe a mental health disorder, maybe some type of anxiety, generally they do. Most people do have anxiety, right? Most people suffer from something. You have to be very careful to make sure that you don't send them down, spiral down, and break it down step at a time. I think is the way to go.
Yeah, I mean, I don't know if you see this. I have to imagine you do, because we do, and our clients are coming up some difficult situations, but I think different emotionally. But do you deal with people making rash emotional decisions without consulting you and doing things that are harmful, that you're then trying to either backwalk, or how often is that an issue? I mean, it's an issue.
It happens a lot. I like to think that from the beginning we have a good relationship and it's trust that's built, and clients don't take matters into their own hands. But there are times when they do. They may pull money from a bank account, or they may change a beneficiary, or they'll do something that is going to get them in a lot of trouble. The worst, I've had so many examples, but one of the worst is I represented an individual who he had a very serious mental health issue, and he was under this impression that he had this girlfriend in another country. Okay, and he actually, throughout the duration of the marriage, within the last 3 years, sent $90,000 overseas to, they call it a phishing thing or whatever.
Yeah.
It was a scam, but it's heartbreaking. And then we got in front of the judge, and there was a counsel fee award that required my client to take a loan against his 401k. He did, and he spent that money. Okay, so now we're talking contempt and possible jail time. That was really difficult. So yes, all the time, some people either they get the emotion gets the best of them, or there's another issue there that just prevents clear and lucid thinking. And that's why, as an objective practitioner, it's very important to have some type of, you have to have control essentially over the client. sometimes clients will take matters into their own hand and write their own letters to the court when they're represented. That's a big no-no. That's a big red flag. So it happens, and maybe I think over the span of 18 years, there's been 3 or 4 times where I've had to actually make an application to the court to be relieved as counsel because the client just wouldn't listen, or did something very, inappropriate. But most of the time, I've had good luck.
And I assume you've, I know I have. I've evolved over the years to spot those red flags typically during an initial consultation, and I feel like we're probably both at the point in our careers where if I see that coming, I'm walking away. I don't care how good the situation is. I've been burned more than once on putting on the rose-colored glasses and thinking I can make it work, and it doesn't work.
Usually my ego will get the best of me. I can handle it, no problem. But then it's like, why did I do this? Can't go back in time. I got a couple of those, and those are the cases that just eat at you. Ones that are the path over
time. It's the 80-20. It's the 80-20 principle.
Yes, right.
That's true.
That's true.
All right, just a couple more.
Sure.
All right. Obviously, you some things are easy. Sometimes it gets ugly. Are there like a couple of specific things that cause these things to go south? And are there any things that you can suggest that would maybe help avoid matters getting ugly? Any thoughts on that?
Yes, and so one thing I didn't touch on is another large portion of my practice is post-judgment work. You have the agreement, here's what it says, and now there's some reason to change custody, or somebody's not paying support, and there's a whole new case that's filed. So my advice, and the pitfall specifically, is when there's a third party involved. A lot of times somebody will meet somebody, and that's okay. All right, we all move on. Life moves on. However, when that third party starts to involve themselves in the parenting decision, that to me is the match. Okay, that is the first match that starts the fire. So I think it's very important for people, not just in the acute issue of the divorce, but then long term if they have young children, you have to establish the boundaries from the beginning. You're the father, you're the mother, whatever. You're the parent, okay? You are the parent, nobody else is. So if you have somebody that you involve yourself with that's trying to interject, I see it all the time, you have to establish the boundary, because that's going to almost always result in some type of litigation. So I would say that's probably number one.
Yeah, it's funny. I hadn't even thought of that, but then as soon as you mentioned it, it's like, of course, that's the biggest problem. You get a third. You get the boyfriend or the girlfriend involved, and yeah, I mean,
it becomes like a fight of like all of a sudden everybody's an expert in parenting, and it becomes and there's these diatribes that go back and forth, and there's conflict, and then just that I think is probably number one. Also, I would just tell people generally, be careful what you write in a text message. You don't want to put something in a text message that you wouldn't want published in a newspaper. And it is just absolutely amazing what people will vomit out in a text message. Or a lot of times in cases where there's high conflict, the court will order both litigants to use a application on the phone to communicate. There's such a thing as like Our Family Wizard or Talking Parent app. And it's free, and it has a schedule, and it tracks communication. It's great for lawyers. I tell people to do it all the time, because then you could print, thousands of pages of text messages without having to, do it through a phone, which is, can be a pain. So those apps can be great. But imagine that. Imagine, you're a parent, and the only way you can communicate with the other parent is in writing through an app. And they still, what people write is just unbelievable.
I mean, I'm sure that's got to impact your cases all across the board. I mean, I'm sure you get people coming in and they've got text messages that a spouse sent to another person.
Or each other. They're just if you want to tone down the acrimony and it's something like, hey, can you drop the jersey off? I forgot, so and so forgot it at your house, and it's you're such a POS, blah blah blah. And it's all in writing and it's all documented, and it's just amazing what
Yeah, I do some sexual harassment training for a couple of small business clients, and I every year I one of my first things is telling that, saying exactly what you said, never write anything in text that you wouldn't want to see on the front page of the New York Times. And inevitably someone will say, nobody's that stupid. And then within a week, I tell them, well, you know what? I just got a case where somebody sent a picture of their genitals to another coworker, right?
Yeah.
It's like they're humans. They are emotional, and they don't, and everybody's guilty of it at some point or another. So, it's funny. We both have kids who are similar ages. Like our kid, my son has a phone now. He's in middle school, and I'm like, do not put anything in writing that will ever, that you would ever not want everyone else to see, because people will screenshot it and it never goes away. I don't care if you think Snapchat disappears; it doesn't.
100% agree. In fact, there's some kids that are getting not my son wasn't involved, fortunately, but there's some issues at the school right now, the middle school. People sending in seventh graders sending inappropriate text messages. It's child pornography, by the way. So, there's that issue too. If you're possessing some of that stuff, depending on the age, and I've used to prosecute cases like that way back when I was a part-time county attorney. But that's a whole nother topic. But I agree. I mean, you can basically one little mistake at a very young age, and it follows you forever. And people, let's face it, people. I'm not trying to make any kind of comment, but people. There's no such thing as context anymore. If you say it, regardless of your age, you're done, and you have to realize that.
Yeah, and to some degree we're getting off the topic, but it's my fault because I mentioned the Snapchat. But at this, the last thing I'll say in that is that I tell my kids this. I'm like, look, your kids, we're lucky that we didn't have this issue when we were kids. That's all I can say about that.
For sure.
So, all right, one last, before we go, any sort of advice, and and you may have touched on it in the last part of the discussion, but any advice to folks to try to make things more amicable on the back end? Is there anything that you can do during this process so that, because look, if you have children, I don't care how much you hate each other, you're going to be in each other's lives for a long time, right? Is there anything that you see that people might want to be thinking about that could help them, manage to get through that part of it without causing too much stress for themselves or their kids?
Yeah, so I give the same advice that I've had my entire career. If somebody's sitting in the chair across from me having a conversation, I say, if you're not in, and I say non-judgmental, if you're not in counseling now, get into counseling. It's very important that you engage in some type of counseling, and that could be spiritually, that could be whatever, but that type of relationship, you need to have that, because this is one of the most intense experiences you can go through. Even if it is amicable, it's still brutally emotional, right? So then I also suggest there's a custody stress prevention class. If they have children, go take that class. It's a good thing to learn about how important it is and how critical it is to be able to, if you can, co-parent, with your ex. That is, it's probably the most important thing. So there's that class. There are co-parent counselors. Parties can get advice on. There are parallel parenting counseling classes you can take where if you can't be in the same room, but you can learn how to communicate with each other in a non-accusatory way and in a productive way. And that, I think, would be the most important as an analogy. When we're talking about our sons, they're similar age. When my son was born, I had to, like everyone else at the hospital, I had to watch the video about not shaking the baby, right? And I'm like, I'm a licensed attorney. Of course I know not to shake the baby. And then on day 3 of no sleep, I was like, thank God I saw the video. Right? So I would say, go to the custody stress prevention. You're going to learn a lot, things that you don't even know, that you're not even thinking about, that at least you can recognize as it's happening. Because I think if a lot of people can just don't send that text message, sleep on it, think about it. I know you're angry, but try to control your emotions and try to understand that no matter what happens in this divorce for the next X amount of years, you are going to have to go to basketball games or soccer games or sporting events or musical events, school events with this other person. and you don't want to ruin it for your child, right? The worst, I mean, I can't tell you how many times, you know, it's a birthday party and police are called. You know, imagine being a 10-year-old kid and it's your birthday party and your parents are fighting so bad, the police show up. You know, and that's a lot of that. Parents that have that conflict constantly and involve the children, and that's the one thing I didn't touch on. Worst thing you can do is involve your child. To talk about your feelings about your ex, and to treat your child as a confidant instead of a child. You know, that is just psychologically debilitating for a child. So I tell clients all the time, your children will be impacted by the fact you're having a divorce. Let's not pretend otherwise, okay? You control the degree of impact. So,
yeah, I mean, that's
a particular way.
That's again, you know, you're dropping some wisdom here, because that's something I hadn't even thought about, you know, the counseling piece, and you're 100% right. Probably we could all use it anyway. So,
yeah, 100%.
Certainly
lawyers.
Well, certainly lawyers who are dumb enough to open their own practices.
Yeah, for sure.
But you know, I think especially since COVID, and you touched on that, and you know, this has been great, man. This is you've really provided a lot of really, I think, helpful information. I think you know, a lot of people can get a lot out of this. If somebody wanted to look you up, talk to you, you know, about some of these issues, where would they find you?
Oh, sure. So my mac-associates.com. My phone number is 518-465-1451. Just Google my name, Barrett Mack. You'll have all my contact information. Be happy to have a consultation with you, give you any advice that I may have. And, you know, I thank you, Scott. It's good to see you. And thank you for having me on. I think this is an excellent idea. And you're the man. What can I say?
Well, and also, if you need Barrett's information, you can always ask me for it. He's very responsive. So yeah, this has been great. It's been, you know, it's unfortunate that we got to get on here to kind of catch up a little bit, but you know, hopefully we can connect again soon. I appreciate you coming on, and you know, we'll talk with you soon.
Okay, thank you very much.
All right, thanks.
Take care.